Good morning, this is your Kelso Report for Friday, December 2nd. I'm your host, Clark Kelso. We have just a couple of one-liners today and one California Supreme Court grant. First, in the area of criminal law, in Flynn versus Holder, the Ninth Circuit reviewed the district court's dismissal of a complaint alleging that a criminal statute prohibiting compensation for bone marrow donations was unconstitutional. The statute at question, Section 274E of Title 42, makes it a felony to knowingly acquire, receive, or otherwise transfer any human organ for valuable consideration for use in human transplantation. The statute goes on to define human organ as the human bone marrow. Now, it used to be that withdrawal of bone marrow from a person was performed by a process known as aspiration, where long needles, thick enough to suck out the soft, fatty marrow, were inserted into the cavities of the anesthetized donor's hip bones. The procedure required hospitalization and general or local anesthesia. Today, a new technique called peripheral blood stem cell apheresis involves removing blood from a donor via a small needle inserted into a vein, filtering the blood to take out the stem cells for bone marrow, and then returning the remaining blood to the donor. The process now is much closer to making ordinary blood donations. The plaintiff argued that criminalizing compensation for bone marrow acquisition using this new technique was unconstitutional, since there is no rational basis for allowing compensation for blood, sperm, and egg donations while disallowing compensation for this type of bone marrow donation. The Ninth Circuit avoided the constitutional issue by holding that bone marrow stem cell extraction using the new technique does not constitute acquisition of a human organ, and therefore Section 274E simply does not apply to the new technique at all. The court vacated the dismissal and remanded for further proceedings, if any. Our next case comes in the area of environmental law. In Montana Wilderness Association versus McAllister, the Ninth Circuit held that the U.S. Forest Service violated the Montana Wilderness Study Act by failing to explain how the wilderness character of the study area was maintained as it existed in 1977, how that wilderness character would have been adequately maintained despite an increase in the volume of motorized and mechanized recreation in the area. Because the Forest Service failed to explain this apparent discrepancy between the statutory requirements and the actual conditions within the study area, the court held the adoption of the service's travel management plan was arbitrary and capricious under the Administrative Procedure Act. Now, this is not a case where the District Court or Ninth Circuit disagreed with the reasoning or analysis of the Forest Service. Instead, this is one of those cases where the Forest Service simply failed to address at all a key issue in its travel plan. Our next case involves an area of criminal procedure. In People versus Arriaga, the Second District held that the prosecution had satisfied its burden of proving by preponderance of the evidence that the defendant was properly advised of the possible immigration consequences of his guilty plea with respect to a plea that was taken back in 1986. Now, there was no reporter's transcript of the plea hearing, and the minutes of the hearing did not set forth the actual advisement, merely saying that the defendant was advised of the possible effects of his plea. But the prosecution put on the stand the court clerk who testified that he always advised defendants that a guilty plea could result in deportation, denial of readmission, and denial of naturalization. This testimony, which was evidence of habit or custom, was sufficient, when combined with the minute order, to satisfy the prosecution's burden of proof. and so the defendant's motion to vacate his 1986 conviction was therefore properly denied. Our next case arises in the area of workers' compensation. In Skiff versus the Workers' Compensation Appeals Board, the 6th District held that the Workers' Compensation Board made a mistake in refusing to apportion payments for a permanent disability resulting from the combination of one specific injury to the employee's cervical spine while working for one employer, and then a cumulative trauma injury to a cervical spine while working for a second employer. The board had held that these injuries, which resulted in the cumulative permanent disability of 100%, were one injury, which could not be apportioned. But, according to the court, Sections 4663 and 3664 of the Labor Code require that the Superior Court undertake an apportionment in these circumstances and find what approximate percentage of the employee's permanent disability was caused by the direct result of the cumulative trauma injury and what approximate percentage of the permanent disability was caused by other factors, including his prior specific industrial injury. Good luck with that apportionment. Sounds to me like a 50-50 apportionment may be in the offing. Finally, we have one California Supreme Court grant arising in the area of health law. The California Supreme Court granted review in El Attar versus Hollywood Presbyterian Medical Center, where just a few months ago the 2nd District held that a hospital must follow its bylaws in conducting a peer review of one of its medical staff. The hospital bylaws governing peer review hearings regarding the denial of reappointment to the medical staff called for a hearing panel made up of physicians selected by an elected executive committee of the medical staff. The defendant hospital did not follow this rule, and instead the executive committee delegated the selection to the governing board of the hospital. Well, the court held that in the absence of a bylaw provision, the elected committee must appoint the hearing panel, and it cannot delegate that function to the governing board. The Supreme Court apparently has granted review to examine the question of how strictly the bylaws of a healthcare organization must be observed in this context. Now, a key to the Court of Appeals holding was its premise that the granting of privileges at a hospital is a property right, the deprivation of which requires some form of due process protections. It may be the Supreme Court has granted review to take a close look at that premise. We'll have to see how this particular case develops. And that's it for today's Kelso Report. Have a great day in the law.